I will now give the floor to our next panelist, Professor András Koltay, the President Rector of the National University of Public Service here in Budapest. And he is a media law expert and freedom of expression expert. And he's going to talk to us today about freedom and censorship, the need for strengthening fundamental European values in the age of online platform, a lecture which is going to be much attended and appreciated by our audience. So Professor, the floor is yours.
Thank you very much, professors, ladies and gentlemen. Thanks for the invitation and for the chance to participate at such a prestigious event. I'd like to talk about the role of online platforms in public communication and the possible regulatory approaches and solutions regarding them. Okay, now I can start my presentation. When we talk about online platforms, we usually mean all kinds of online services which makes the users capable to communicate with each other and interact with each other. So we talk about social media platforms, search engines, web stores, and blog providers, and so on and so forth. As I'm sure you all know, all these platforms are able to influence the public sphere, in most cases much more effectively than government itself or even the European Union itself. They are private actors, so they are not bound by any constitutional guarantees of freedom of expression, and that's why they have the opportunity to influence the public sphere with much wider scope than states do, who need to recognize the constitutional guarantees of freedom of expression and freedom of the press. And they actually do regulate user speech. I call it, in the latest stage of my presentation, I would call this private regulation. They can set the standards and they can oversee the standards. They can ban their users. They can sanction the users. That is proper regulation, but it's a very different kind we are all used to as lawyers. Social media is the most influential online platform among these platform ecosystem. They enforce their private regulation through their contract with them. So private law is very relevant in this regard. They set up rules. We can call these rules either terms of services, codes, standards, whatsoever. They all have binding force between the parties, but the content of these rules are established by the platform itself. The user only have the decision to sign up for the service or just to avoid the service. If somebody wants to speak publicly and wants to have his or her voice heard in the public sphere, then probably it's only one opportunity, just to sign up for these platforms. And these rules, this private regulation directly affects freedom of expression, not in the constitutional sense, but in the practical sense. Let's go back to the roots of European doctrine of freedom of speech. Maybe it seems a bit vague to talk about European doctrine, but I think, and my researches in the previous years or decades established this point, that all European countries or European national legal system have similarities, have common points, have serious overlaps, which makes them similar to each other in this regard. So I think it makes sense to talk about the European doctrine of free speech, even if freedom of speech differs in every country and the exact boundaries, regulation can be very diverse, even in Europe. The core of the freedom of speech, the free speech protection, is the protection of the freedom of discussion on public affairs. That is the most important feature of this constitutional right. People can say whatever they want, they influence public issues, the discussion on public issues. That is a very important foundational feature or cornerstone of modern democracies. The other side of this coin is that freedom is not without limitations. Freedom needs to be balanced out between the freedom to speak whatever one wants and human dignity. That is, in the practical sense, this balance is established in the defamation law, privacy law, hate speech regulation, and all kinds of other speech regulations. That is very important in Europe. Human dignity is the general limitation, general value, the protection of which forms a standard or a justification for limiting freedom of speech. We can also talk about the European doctrine of the freedom of the press. It's a bit more complex or tricky. When we talk about press freedom, we always mention the number one most important justification of press freedom, that is the press's duty to serve democracy. Press is free because they have democratic duties. The European Convention of Human Rights, Article 10, sets out this duty in its official text. It says the duties and responsibilities are there for everyone who exercises freedom of expression or freedom of the press specifically. But the tricky part is that even if we talk about these democratic duties and democratic obligations, in the real sense or in the legal sense, it's not a legal duty, not a legally recognized duty, only a moral expectation. So no press outlet and no media outlet is bound by this text of the European Convention of Human Rights or either any other legislation in national legal systems. They can basically talk about whatever they want. If they decide to avoid informing the public on public issues or only talking about, I don't know, showing sports programs in the case of broadcasting or hunting in the case of a hunting magazine, they are free to do that. That is an ethical expectation, and when constitutional courts and national legislation talk about the duties of the press, they probably exercise wishful thinking and think that there will be some press outlet in the market who will act responsibly and serve democracy. There's a very limited legal rules applicable to the press which are related to the democratic role, and that is the right of reply, which is a regulation that is present in all European Union member states. The situation is a bit different in the case of broadcasting. That is television and radio services and video on demand services regulated in a bit more extensive way, but also they don't have any legal duty to serve the public interest. If they decide to inform the public, then these obligations come into play, and they have the obligation to impartial news coverage, for example. Without duties and responsibilities, the press can enjoy privileges, so some extra rights which are only there for the press and not applicable generally to all kinds of speakers. There is just some examples are there in the slide: protection of anonymous sources, protection against search and seizure, exemption from testifying duties, some access rights to closed places or closed events, tax benefits, so on and so forth. They are all there to incentivize the discussion on public issues. So if the press decides to cover public issue, then they can enjoy these privileges. But it's also something that is close to the ethical sphere. So the decision to serve the public or to avoid serving democracy is a pure ethical decision by the press. What is the role of of the legal regulation by the states, to important duties of the state in this regard. They need to set the standards, speech standards, that is, and maintain the right balance between freedom and human dignity. That is something that was started 30 years ago after the Iron Curtain fall in the case of Hungary. And after 30 years, we have a very nuanced, very balanced and very rich case law and legislation in this regard. The other duty of the state is to protect or to provide the procedural guarantees for speakers. That is independent adjudication, the right to judicial review, well-reasoned decisions by state authorities, transparent decision-making, and all other types of procedural guarantees. Why are these basics important in the case of online platforms? We can ask two very important questions. One is that whether free speech and press freedom doctrine is relevant to the regulation of platforms at all. And the second is that do we expect them to recognize their social responsibility to inform the public? This is an ethical issue or not? My personal opinion is that we need to answer both of these questions in the affirmative. But if we would ask, let's say, a shareholder of any online platform, probably the answer would be a little bit different. The regulation of social media with a view to free speech doctrine, that is the title of this slide. If we answer these two questions in the affirmative, then we can think about the next steps. Number one problem is that if we allow these platforms to keep the balance between freedom of speech and human dignity through their private regulation, probably will face serious difficulties. They do their job, so they actually regulate free speech. They have these private free speech codes. In the case of Facebook, it is called community standards. They have the private adjudication system, obviously without the necessary procedural guarantees. I'm sure you're all familiar with the case of Donald Trump, former president of the United States. What happened to him was a very typical example of this private free speech regulation. And even if we can argue for and against the banning of the former president, even the thing that something like that could happen in a very important part of the online public sphere is a bit frightening for all lawyers who acknowledge the importance of constitutional free speech guarantees. What is the case with the press freedom doctrine and how platforms can recognize these press freedom, the main foundations of this doctrine? Obviously, in the case of online platforms, we never talk about duties and responsibilities. But theoretically, we can raise the issue whether they should be, even if not in the legal sense, but in the ethical sense, they should be forced to recognize these duties and responsibilities, what we usually talk about in the case of the press and media. We can raise the question whether they need to be forced to cover issues of public interest, whether they need to keep a balance and provide impartial news coverage, whether they should provide certain public service content or recognize the right of reply. These are all features of the regulation which are present in the case of press or media, but not present in the case of the big online platforms. The problem is with this, as media markets as a whole may be capable to maintain the balance between individual interest groups. Just in the practical sense, it means if you buy one piece of newspaper, which is partisan and follows a party line of a certain political party, then you can buy another one, and these two newspapers can balance out each other. But that's not the case in the case of online platforms, because online markets tend to be monopolistic, so you can't switch, because if you are a user of Facebook, then probably you will get your information on public issues from that platform. And the platforms, through the artificial intelligence and through the algorithm they use, they prioritize between users' content, which means that they are capable to push certain content to the users, and they are also capable to hide other kinds of content from the users. If they decide one day that they don't want their users to follow any information that relates to public issues, then they can achieve that in a very short period of time. That is what happened in Australia this January, and that is very problematic if you regard these platforms as a very important part of the online ecosystem or the public sphere generally. What can be done with this problem? Obviously, the answer is still hangs out somewhere, so we can't answer this question probably in the foreseeable future. But we can think about the different types of regulation, and probably the answer to this question will be complex, and probably all different types of regulatory approaches can interact with each other and somehow solve this situation. One possible answer is that we don't need regulation at all. That is a little bit outdated answer that goes back to the 90s, the last century. The internet should be preserved as the Wild West of the United States back in the late 18th, early 19th century. So no central regulation, no legal regulation is necessary. I think this approach went out of fashion in the last couple of years with the rise of these huge online platforms. The second possible answer is that the state needs to regulate online platforms strictly, maybe similarly to broadcasting, setting the standards applicable to these platforms and oversee these standards and users' behavior and the platform's behavior. That is something that is done by media authorities in the case of broadcasting. Probably won't work in the case of online platforms, so no one really thinks about this approach as very valid or relevant in the case of platforms. Number 3 is the co-regulation. That is something already present in the European Union regulation and national regulations, so joint efforts by market players and state authorities. That is co-regulation. Current e-commerce directive is a typical example of this. Through the notice and takedown liability system, it establishes actually a co-regulatory system is already in force in all European countries. With all these serious difficulties as well. Self-regulation is another possible answer. Problem is with self-regulation that it needs to be independent. The platforms are not interested in independent self-regulation. They try to solve it internally. Facebook's newly established oversight board is one example of that. But my personal opinion is that is more like a communication tool for the platforms and not the real solution to the problem of private regulation. Private regulation probably would be present in the foreseeable future because under the current constitutional free speech doctrines, private regulation cannot be banned by the state. But it's also very problematic, not only in the case of online platforms, but generally in the case of labor law, for example. Private regulation can empty the constitutional free speech protection, and that is something that needs to be done about. And the last one is private law, private contracts. It's a newcomer on this field. We usually did not talk about private law and the law of contracts in the case of media regulation or internet regulation. Through the horizontal effect of basic rights, that is the German doctrine, private law theoretically is capable to balance out this naturally unbalanced situation between platforms and the users, if platforms can be forced to recognize this horizontal effect. And my last slide is what the future may bring, the latest developments on this field. The very recent development is the Digital Services Act proposal by the European Commission. It follows the path of the already well-known e-commerce directive. Aims to strengthen the co-regulatory system with certain procedural guarantees. Probably it will be a step forward, but also the shortcomings are visible, because the Digital Services Act does not aim to limit the scope of the private regulation. The AVMS directive, it's already there in all national legal systems after the implementation, 2018. So it was a very important step forward. Video sharing platform is a new definition of the directive, and all the big social media platforms are under the notion or under the definition of video sharing platforms. So the regulation of television, audiovisual media generally, and the social media platforms are getting more and more similar, but also the differences are still there. National regulations are also very important. Germany, Austria, France, some other European countries introduced national regulations on this field. My problem is with this type of regulation is that they are all incentivize the deletion of illegal content. So they make the platforms even stronger and give them stronger tools for regulating the users. Whereas the Polish proposal goes to the other direction. It aims to protect free speech by banning private regulation, and I'm really interested in seeing where this Polish legislation will go in future. And my other remark, my last remark is that the increasing importance of private law is there in protecting individual rights. So probably private lawyers will be also interested in the regulation of online platforms in the future. Thank you very much for listening to me.